Well, I've been a medical librarian meeting the information needs of clinicians and pharmacists and nurses for 20 years now, but my introduction to the legal space came in 2018, and I had a agency reach out to me out of the blue. I wasn't listed anywhere. I didn't know that this was a need that was out there.
Is there any misconception that you feel that you have seen attorneys have when it comes to medical research and how it kind of applies to their cases?
You might have such convincing experts on both sides with identical CVs. And so, folks are just going to say, well, I don't know who to believe. They both were incredibly savvy and communicated well. And then the tiebreaker might really come down to, the medical evidence.
Welcome back to On the Stand with Ashish Arun. Today's guest brings a unique and often overlooked perspective to the expert witness ecosystem. Michael Graham is a medical librarian with over 20 years of experience who has built a specialized practice at the intersection of medical research and litigation support. As the founder of Graham Med Legal Research, Michael works with attorneys and expert witnesses on medical malpractice, mass tort, and personal injury cases, helping them navigate the complex world of medical literature. With access to over 100 medical and scientific databases, he provides a service that many attorneys don't realize they need until they see it in action, systematically finding, evaluating, and challenging the medical evidence that can make or break a case. What makes Michael's role particularly interesting is that he's not providing medical opinions, he's providing the research backbone that supports or challenges those opinions. He helps attorneys understand not just what the medical literature says, but whether it's methodologically sound, current, and admissible under the Daubert standard. So today, we'll explore his journey from traditional medical librarianship to litigation support and learn why having a medical research expert might be one of the most underutilized strategies in complex medical litigation. So on that note, please welcome Michael Graham to the stand. Michael, welcome to the show.
Yeah, thank you so much for having me. I've really been looking forward to our conversation. So
have I. So, Michael, you are a medical librarian who works extensively in litigation. So now that's not a career path that most people would imagine. So how did you discover this intersection between medical research and legal work?
Well, I've been a medical librarian meeting the information needs of clinicians and pharmacists and nurses for 20 years now, but my introduction to the legal space came in 2018, and I had a agency reach out to me out of the blue. I wasn't listed anywhere. I didn't know that this was a need that was out there. And this service said, hey, we have a law firm. They're dealing with a very medically complicated med mal case where a medical device has failed, but the physician, they also felt like had made a major error because he failed to recognize that the device had failed and persisted with the treatment, and the patient was irreparably harmed forever. So they were drowning in the medical literature. There was over 1,000 different studies and publications dealing with this technology and procedure. They were also a boutique law firm. They only had 3 attorneys. So they felt like, we don't know what literature to look at. We're not sure we're finding everything. This could expand to an MDL. They just needed a lot of help with specialized medical research. They didn't have access to the databases. And so, I worked with them and had a great time. I loved the challenge. It was a blast meeting their needs and just really interesting. And at the end of the day, it was still the same as meeting a patient's needs. There's a human being on the other end of this information that I'm providing, and there's a story there. So I really loved it, and that was my point of departure.
Mm-hmm. I was listening to another podcast that you were on, and you talked about having a varied career path before becoming a medical librarian. So can you share what those experiences were and how they uniquely prepared you for this work? I'm basically trying to map your journey as to how you ended up first becoming a medical librarian, and obviously the litigation consulting experience that you just shared came your way.
Yeah, I think if you told my 18-year-old self you're going to be a librarian someday, I would have said, "Oh my God, that's so boring." Like, what happened to me? Right out of high school, joined the military and end up after that, working my way through college. And then I got introduced to academic libraries. And then in the late 90s, early 2000s, I found myself working at an intellectual property law firm that was dealing with some pretty big companies of the day. A lot of those tech dinosaurs are not walking the earth anymore, like Sun Microsystems and Nortel, Lucent. But yeah, that was my introduction. And I think that working in that IP firm also set me up very well for what I'm doing now because I
Yeah.
understand the nature of legal work and the fast pace and the high stakes and how you've got to just be precise and everything has to be done at the highest possible human standard. And so I think that, and just getting the a feel for the culture of large law firms was very helpful.
Mhm. Today's episode of On the Stand is brought to you by Xlightum, the AI powered platform where attorneys find expert witnesses and experts grow their practice. Every week, hundreds of new experts join Xlightum, giving attorneys instant access to qualified witnesses without any finder's fee or markups. Need someone else to handle the vetting? Our concierge service does it all. You only pay when you retain an expert we present. So whether you are searching yourself or letting us do the heavy lifting, Xlightum makes expert discovery fast and smarter. Visit Xlightum, that's exlitem.com, to find your next expert witness today. So, for attorneys listening who may not understand the role, because again, like we noted in your introduction, it's most attorneys don't realize they need this service till they see this in action.
Mhm.
So, if I am an attorney doing medical malpractice work or product liability work where a medical device is involved, how is your role different from a medical expert who
Mhm.
who's maybe using the device in practice and
Mhm.
has like a different set of credentials,
Mhm.
but those credentials are relevant to the case?
Yeah, great question. So yeah, I'm considered a consultant and not an expert.
Mm-hmm.
And my training and background come from learning how to conduct exhaustive, comprehensive literature searches and research so I can make sure that nothing has been missed. And all, of course, my training and education is in knowing what database to use and then what search strategy and tool and technique would be best. And that's something that, every single search is going to be a little bit different. And so that's kind of my training is making sure that every piece of evidence is uncovered and known. Whereas an expert, definitely a physician, their training and education and experiences in patient care and procedures and a thousand other things they're expected to know. And one of those kind of things that often falls by the wayside is being trained how to search in databases, how to evaluate sources. They get a little bit of exposure to that and they'll use it sparingly throughout their career, but they don't perform that task and that role 5, 6, 7 days a week like I do. So,
Mhm. No, no, I mean, that makes perfect sense. And you've also said that you have access to over 100 databases. So before I ask you to walk us through your research process, that's another point I would like to make, that probably most medical experts who are now in practice, or even if they're teaching, they may not have access to so many databases.
mhm.
They may even not know about all these databases. So I can totally see how that itself is an additional edge that you would bring to the case. But walk us through your research process. When an attorney comes to you with a complex medical malpractice case,
Mhm.
where do you start?
Well, first, I like to get as much context and background on the case and the patient as possible, even if they feel like something might not be pertinent. I like to kind of understand the medical journey of this individual, what happened to them before this event occurred, who are they, and just kind of learn about what happened to them, what's alleged to have happened, all the different, sometimes there's been so many procedures done and complications and so many different complexities. I like to know all of those. And then from that, flesh out all of the key terms that are pertinent so I can start to build out a really comprehensive search strategy to make sure there's no synonyms that have been missed. Um, there's just kind of no corner that hasn't been investigated. And then
And
I, oh, and then next I'll, of course, start to ask myself, well, what are the must search databases to look at? You start with PubMed and maybe, Ovid and then go down the list from there. So making sure I'm using the right tools for the job.
Mhm. And do you have like a practice area wise set of databases? I know it's not a hard and fast list that you would have, but do you still have like a rough list that, okay, for medical malpractice cases involving these kinds of injuries, these are the 8, 10 databases that are more useful, and
Mhm.
then it's a different data set for product liability cases involving medical devices?
Yeah, absolutely. PubMed is probably my go-to, and then I also use a very deluxe package I have with Ovid, where I can make sure that I'm also searching conference abstracts and poster sessions. So for a really fast-moving topic like adverse drug effect or a medical device or something, I'm going to want to make sure that I use Ovid so I'm kind of getting a sense of the literature that might be forthcoming. Like, okay, there's poster sessions and conference abstracts, but no full articles yet on this or very limited. So I can kind of see that's coming in a few months. And those are kind of my go-to. And then for things that might be a little more scientific and a little less medical. Scopus and Web of Science, they might get into a little bit of biochemistry and different academic things that might not be found in PubMed.
And there used to be this Beale's list of predatory publications. I'm sure you've heard the name. And I think a few years ago they took it down. The professor who used to maintain it, he took it down. And we don't know why that happened, but it did happen. So, do you have your own list of predatory journals where, if you see somebody publishing there, you know that, okay, this is how these journals work? And is
Mhm.
that knowledge useful in the value that you provide to an attorney?
Yeah, that list is so extensive. I don't think anybody could possibly keep up with it. There's hundreds, and probably if you want to look at other industries, there's thousands of predatory journals. And so there's kind of just a litmus test that a good researcher would use to look and see if this publication passes the sniff test. But even really reputable publications, there's situations where you'll have a paper submitted and you'll have every single reviewer raise some serious questions about some methods, and they'll recommend to the editor, I think you need to reconsider publishing this, or we need to really, slow this down. But there's some other pressures out there. The editor is like, I know this is going to be a very popular article, and they'll push it out
Yeah.
there, and then a retraction may or may not come later. So there's all kinds of forces in the publishing industry that are at work behind the scenes, and but there's often like a sniff test for the predatory journals, and some of them look great,
Mhm.
some of them look professional and first glance, but then when you really dig deep, you'll kind of see these cracks in their methods or lack of methods, and you can tell like, okay, this there's something going on beneath the surface here.
Mhm. So, in your opinion, if I, as an attorney, am looking to retain an expert and I see that they have published in a predatory journal a few articles, then should that impact my decision on retaining them, especially if the case involves peer review articles and something cutting edge, which is not
Mhm.
really established science? What's your take on that?
Yeah, that's an interesting question. I would say it depends on the situation. If somebody maybe earlier in their career they were slow to get some traction, and they'd had a couple things published in some predatory journals or things that are on the edge of that. I might not hold them against that if that was a long time ago and early in their career. But if they have 50 publications and you're seeing a large percentage are at these fishy publications, that will be something worth looking into and definitely evaluating critically those sources and publications. So yeah, it depends on case by case basis, but
Let's talk about the hierarchy of medical evidence. So, how do you explain to attorneys why a case report is different from a randomized controlled trial and why something like that matters in court?
mhm. Yeah, some attorneys are so incredibly medically and scientifically savvy. They might fully be aware of that. Some that are maybe don't necessarily handle a lot of med mal cases, or they don't maybe have a ton of cases go to trial where the evidence is really hyper evaluated. They might not be so sure, or they also might just trust the expert and say, don't even, I trust their citations and I'm not going to even look at that. Um, yeah, so sometimes I do have to do some education in that area. And we have the evidence pyramid. Probably a lot of folks have seen if you've had some basic science classes, and at the top are systematic reviews and meta-analyses and guidelines, and all the way at the bottom you have, opinion pieces that some physician has written into a journal and just said, hey, I think this is what's going on. And then just slightly above those opinion pieces, you have those single case studies, like you mentioned, and that could be an early signal of something going on. Like, okay, we maybe this device or drug, we don't understand all of the mechanics behind it. And we're seeing some symptoms and some cases come up, and we're going to see more momentum there. Or those case studies or case series, which are just one individual for a case study and then maybe 10 or 12 for a case series, that might be just kind of a unicorn, or you have a million people undergoing this procedure and you're going to have some flukes and some unicorns happen in there. And yeah, it's just more noise than signal coming up.
So, do you have a war story where your research, like maybe changed the trajectory of the case or had a deep impact where attorneys were like, oh, wow, like this is something that we did not really expect to happen?
Yeah, I have this scenario play out several times a year where there'll be a case and there'll be two or three outstanding experts on each side, and they have nearly parallel CVs. They've been practicing their vocation for decades. They have all the education, everything. Their reports are well written, but they don't cite any evidence. And so you have one set of experts maybe saying that your causation is either implausible or impossible, the opposition saying, no, that's what happened, and here's my experience to inform
Yeah.
me. And so I'll have an attorney reach out, or maybe an expert, just saying, hey, I looked, I couldn't find any cases that were like this. Can you find something? And I'll find some case studies or case series of that exact scenario unfolding. And it might be a really rare situation, but it at least will inform like a jury and a judge that no,
Yeah.
this is possible. And here's what those case studies showed us about maybe this injury or this adverse outcome. And it's plausible. And here is what those researchers found was the cause. And kind of at least give folks some evidence to back up those claims. And then sometimes there's just even larger studies that are missed or misunderstood that I'll provide, and we'll end up kind of illuminating a really nuanced gray area in the medicine.
So let's talk about the literature evaluation services that you also offer. And vis-a-vis the holy grail of expert witness admissibility, that is the Daubert standard. So when you are reviewing a piece of literature, what red flags do you look for where you are assessing if a particular study will pass the muster under the Daubert test?
Yeah, that's a great question. So I think when evaluating the literature, I see a lot of times where it might not be pertinent to the case at hand, or it might be misused. Kind of a prime example is, say we have a patient and they're an American male in their 50s and trucker, maybe they're Hispanic or African American. And the opposition has cited a Chinese systematic review. So whether it's
Mhm.
the expert or the attorney, grab this thing, said, oh, well, systematic reviews are the gold standard. So great. And they're holding that up to compare that to this
Yeah.
patient. And it's not apples to apples with, say a foreign study like this. You have a different healthcare system, you have different technology being used, you have different physician training, different patient population. Sometimes it'll even be an outpatient procedure in another country or another context, whereas in the States might be only inpatient, or your rural medicine case and where they don't have all the great resources, but yet somebody is citing a study at John Hopkins where they have all of the toys and the bells and whistles and every new technology at their disposal and every resource they could imagine. Yeah, so yeah, I hope that answered your question. Kind of went off a little bit in the
Mhm.
weeds, but and yeah, with the Daubert challenge, yeah, I see a lot of sources that are either misused or an expert has not cited any evidence at all. And so, that calls their methods into question. Or if somebody evaluates their citations a little closer, they'll say, well, that's actually not what this article is saying, or it's so far removed, or maybe the source is very dated that they're using. So,
Mhm. No, I have actually seen a lot of medical experts. They would write these reports and not cite anything.
mhm,
So, like you said, and we, like, our core business is to look and analyze challenges to expert witnesses.
mhm,
And again, I mean, that's not something that we have seen a lot of attorneys do, where they are questioning that, okay,
mhm,
they'll try and attack the qualifications or the methodology of the expert, but they would very seldom would they try and attack the fact that this expert has not cited sufficient medical sources, literature sources, journals, articles, and so on and so forth to support their methodology. So,
mhm,
and then in 2023 December, they came up with an amendment to Rule 702 where now they say that, okay, you should not only be applying a scientifically reliable principle to the facts of the
mhm,
case, it should appear that you have applied, which means now
mhm,
the burden is on the expert, on the party retaining the expert, to establish that the expert has used a scientifically reliable methodology and they have applied it to
mhm,
the case. But unfortunately, courts have not really applied that, the new stricter standard. They're
mhm.
still going along with the old, more lenient standard pre amendment. So tell me something. How do you handle situations where the medical literature is conflicting or
Mhm.
evolving? There are not enough studies, or there are a few studies that support and that oppose the stand, like both the cases are
Mhm.
true. So, how do you handle those situations?
Yeah, and that's something that really confuses a lot of folks with medical literature is
Yeah.
there could be certain type of treatment, and there's 100 studies out there, and 50 say, yes, this is efficacious and it's great.
Yeah.
You should use it. 50 will say, this might not be so safe, or there's no positive outcomes. And so, I'll work with, when I work with physicians in a clinical setting, they'll say, I don't know what to make of this. So typically when that happens, eventually you'll see a good systematic review and a meta-analysis start to be formed where a team has looked at those 100 trials or studies and said, okay, well, what's going on here? Why are we getting such conflicting differences? And they'll have a very transparent methodology, and they'll say, okay, well, here's our strength of evidence that we're looking at, and it'll kind of answer those questions. So some of those sources at the top of the evidence pyramid would be ideal for an expert to look at to kind of differentiate, signal from noise.
Mhm.
And back to speak what you mentioned with a lot of experts not citing any sources, I see that so frequently.
Yeah.
And it's pretty crazy. You'll read a 12-page expert report and there'll be nothing cited or
Okay.
maybe one guideline dropped in there.
Yeah.
And and then the opposition saying the exact opposite, and they just looked at the same facts and reached a different conclusion. But it's like, well, what does the evidence say? That's really going to be helpful for a judge and a jury to say, well, who's telling the truth? They both are amazingly qualified and maybe very articulate in their testimony and their reports, and I can't, tell who is got the evidence on their side. And so, yeah, I'd like to see that happen more often, where evidence is actually research has been done systematically, and the experts considered what the literature is saying, and then they're backing up their claims with, yeah, we're supposed to be practicing evidence-based medicine, and I
Yep.
don't see sometimes evidence of the evidence-based medicine in some of the reports. So yeah.
It's more common than we would like it to
Hmm.
be. I think that's the case. In fact, one of our oldest customers, he's a plaintiff's attorney in Texas, and he told me that one of the biggest use cases that he has found for our expert witness opposition research services, that we are able to pull past deposition transcripts of experts.
Hmm.
And he found that in previous cases, experts have taken completely opposite stands than what they are taking in his case on similar facts, just because they are testifying for a different side.
Hmm.
So, have you ever found instances where experts have cited studies that actually contradicted their conclusions? Or maybe they have written something in the past where they have taken a stand,
Hmm.
but then in the case they are saying something completely opposite.
Yeah, I do see that. Sometimes I'll see in some expert reports, I'll see a cherry-picked quote out of a study
Yeah.
or an article, and I'll pull the full text and I'll look at it and I'll say, well, that's not actually what's being said if you consider the whole context and the
Right.
data in the article or the source. They just got this one little quote, like they were writing a high school paper or something. Well, this sentence says what I want it to say. I'll drop it in there, and then nobody called them out on it. Nobody looked at the study and said, well, let's see what this is actually saying, what the data is supporting, and then look at other sources. And yeah, so I will see that.
And do you have like a specific process for identifying whether an expert is cherry picking literature versus they are presenting a balanced view of the science?
Yeah, there's a kind of a bunch of different techniques you can use. One of them could be a red flag for if they're cherry picking literature is if they're using really dated sources. And I know there's a lot of newer literature. So they're citing stuff from the 90s and the 2000s or
Hmm.
15-year-old studies. And I know there's a lot of new literature that is probably a red flag. A second red flag is if maybe they cited two studies and there's 200 out there, and I'll kind of just
Hmm.
do a lay of the land and I'll say, well, there's only like six of these 100 studies said that this procedure is or is not, efficacious, and they happen to cite that small percentage.
Yeah.
That's kind of a red flag. Um, and also small study sizes, if they neglected, okay, this issue has already been kind of beaten to death in the medical literature. Like we have a Cochrane systematic review, and we have 10 other great systematic reviews and meta-analyses. And then we have a bunch of cohort studies, but they've cherry picked one case study or a case series that are, it's just like picking a very small sample size and holding that up is like, no, this is more the outcome or the norm, or yeah.
So, probably one question that I can think of that attorneys could usually always ask a medical expert is that have you considered all the latest studies and literature on this topic, especially if they have cited something like the latest study they have cited is back from the 90s.
Mhm.
So, are there any other questions that you can share which attorneys should ideally always ask when they're deposing a medical expert where literature is involved?
Yeah, I can think of a couple. Probably a really good question, and definitely when you get into like MDLs and things where they're really digging deep into the science and they're looking at everything with a fine-tooth comb. I think asking just maybe their methodology, if they're citing something or if they're not, but if they're citing a couple studies, maybe just briefly asking them like, what's your practice around research because sometimes you'll have an expert that they're familiar with a specific procedure, but maybe they don't actually perform that procedure. And so they're
Mhm.
still expert enough in that field. They're like, well, I prefer to use this other procedure. I just don't like that procedure for whatever reason. It might kind of bolster their report and testimony if they've done that research. And so maybe, yeah, just asking that. I've seen a couple MDL transcripts where the opposition asked an expert, like, where did you get your literature? And they've been like shockingly transparent, where they just said, well, the attorneys gave me a package of what literature I was supposed to consider, and that's what I considered. And they didn't say I looked at that and then I did my own research, or they'll say I heavily looked at that, but then I also looked at PubMed. But then when they were crossed, it was clear they're not familiar with PubMed. They really hadn't done their own searches. They couldn't come up with any type of search strategy that they had done. Um, yeah, so I think for some cases, maybe an attorney doesn't need to like grill an expert on that, but for
Mhm.
some of the higher stakes ones or ones that maybe there might be some red flags around the literature that they're
Yeah.
citing, maybe just good to ask, like, where did you come up with this? What
Yeah.
were your methods? Yeah.
Mhm. So you said that you are not an expert, you don't testify, you are more of a consultant
Mhm.
who is brought in to review the medical literature that maybe the retained expert is reviewing or the opposing expert has already reviewed and like cited in their report. So is there collaboration between you and the medical expert who is going to testify? Like, do you also help them do the medical research and get the relevant literature for them? Like, do you also provide those services? And other than that, what are the other ways in which you collaborate with medical experts on the case?
Yeah, so it's kind of funny, but often when I'm contracted by an attorney or a law firm, I won't
Mhm.
actually have any communication with the experts, and I
Okay.
more often than not, I don't even know who they are. I'll just do a large systematic literature search and put that in a spreadsheet or upload those into a file, and then the expert looks at that and they have the full range of literature, and then they can parse through that to render their opinion. And I'm a neutral information provider, so I'm giving them everything. I'm not just giving them something that says the outcome that they want. They're getting
Okay.
everything, and then they can choose to evaluate how they want. And then I also work directly just with experts or legal nurse consultants when they might be it's kind of a gray area or it's a very complicated case, and they want to know, like, I'm leaning in this direction, not taking the case, but I want to know what the evidence says, and they're not comfortable, or maybe they don't have the time to do all the research because they're in their clinic seeing patients and
Mhm.
they have all these other burdens. They're not going to sit on PubMed for 6 or 7 hours to make sure they get everything. So in that case, when I work with those experts, um, yeah, there will be a lot of back and forth where maybe they'll give me the case context and then I'll kind of formulate these key clinical questions that are at the core of what's going on. And then I'll research each of those key questions and then give them all that evidence, and then they can look at it and they can say, okay, that's backing up my opinion, or that's something different. Maybe I need to reconsider. And then they have that, yeah, at their disposal. So
Mhm. So in these cases, then you're working with these medical experts and LNCs at the pre-litigation stage, where they are figuring out if the attorney should be taking the case or not. In other cases, when it's not pre-litigation, when attorneys are coming and retaining you, what is the ideal time for an attorney to bring a medical research expert into a case?
yeah, I would say not super early in the process, and clearly not at the end. I feel like so many attorneys are very medically savvy, and they can get on Google and they can say, okay, I'm not familiar with this procedure and what's going on, and they can kind of come up with a couple review articles and do their own research, and they can get caught up to speed and say, all right, well, now I understand the context, what's going on, what was done, what should have happened. and they can kind of do their own preliminary research. And same for the LNCs and experts. It's kind of in that middle area where maybe an expert is on the fence about taking a case and they want to know, like, is my opinion well supported? Is the evidence behind me that I'm
Hmm.
useful? And then also, yeah, definitely with the higher stakes cases, as an attorney gets in and they're funding more of, this expensive trial, they're going to want to know that the evidence is behind them. So yeah, I think just somewhere in that middle area to know that they have everything and to bolster what they're thinking and kind of maybe also be aware of any possible limitations or weaknesses that could come up, some contradictory evidence. It's good to know what's out there
Hmm.
and know that you've got everything.
So you noted that again, like some attorneys are medically savvy, but the ones those who are not, do you offer any training services where like you possibly train attorneys or even law librarians who are not medical librarians but they work in a law firm and the law firm does medical malpractice? So are you open to training these law librarians and attorneys into how to conduct medical literature research if they wanted to get your services for that?
Yeah, I do a lot of that. A lot of that takes place informally just through conversations with attorneys. They'll have some questions
Hmm.
like, hey, does a conference paper or abstract always turn into a full-blown article? It might be something that they don't know, a small little question.
Hmm.
And so there's a lot of informal education. If somebody wants me to, train, yeah, like you said, a law librarian or a junior attorney, I can kind of walk them through things about like, well, how do you decide what database and then what search strategies should you use, mesh terms and key terms and things to overlap these strategies and make sure you're getting everything. And so then they can take those tools off and they can, when they're doing their pretrial early stages research, they can make sure, okay, I didn't just grab two sources and they're not good. Um,
Hmm.
so yeah, but a lot of what I do in the education space, yeah, it tends to happen informally as
Yep.
questions come up or like, okay, this is why we're not seeing any systematic reviews and meta-analyses at this stage with this adverse drug effect because it's a little
Hmm.
too early in the publication cycle, which might take 10 years from early signal of one case study all the way to the end where you have guidelines being rewritten around something. So
No, fair enough. And you told me that you were introduced to the world of litigation consulting by an agency. And after that, how did you go about building your practice? Like, was it challenging to educate the legal market about this specialized service? I'm sure you're still, like trying every day to spread the word and the whole education. I don't think educating the legal market about these services will ever stop.
yeah.
But what has your experience been like from that first case till now
Mhm.
about spreading the word and doing some business development?
Yeah, those early years, I was just relying on a single agency, and so an attorney would have to go to them and say, "Hey, I need a medical librarian or a medical researcher." And most folks have never even heard of a medical librarian. So in those early years, I was only getting a handful of cases every year, and I kept telling myself, "I've got to learn to market myself and get some business acumen going." And even if that wasn't, my forte, we live in a wonderful world where there's so much great education out there. We can learn any skill we want to learn and get better at anything we want to get better at. So a few years ago, yeah, I told myself, okay, I'm going to learn to market myself better and kind of get the word out there about, how I can be used well and how I differentiate from an expert or, an LNC, what I do differently. So that was a big part of my evolution. And there's still a lot of attorneys and experts out there that are still like, I don't care what the evidence says. I don't need it. I don't put it in there. I've met a couple med mal attorneys in social situations, not professional. And so we got in a conversation about what do you do? And I had several of them. They say, well, I just sprinkle some citations, into my motions and briefs and these things, and they just sound good and they look like they're pertinent and they're kind of background and no one's ever called me out on it. So I try to get the word out that if that worked in the past, okay, it might not work in the future. And if you get somebody on the other side of the aisle that they are going to call you out on that, or at least just throw a Hail Mary pass and see, like, well, let's call that into question, and let's put that evidence under a magnifying glass and see if those citations really do hold up. And yeah, like you mentioned, with the rule changes, their judges are getting more and more medically and scientifically savvy. I've seen some federal judges where they're actually asking experts, like, how did you come up with these studies? Like, what was your research methodology? And they'll say, okay, I got into PubMed and I did this and that. And the judge will actually evaluate, like, okay, they actually did use some databases. They mentioned them. They mentioned their processes. So there's a clear system there, and I understand their logic and their process. And okay, great. But a lot of judges are not so much. It's
Mhm.
kind of a luck of the draw, like who you get and what questions or inquiries they're going to have. And yeah, you don't want to build your case around a lack of evidence or a pile of evidence in the opposition. So,
No, I think the burden is also on the opposing counsel, where if I, as an opposing counsel, am looking at any report which has citations, the burden is on me to get it cross verified
mhm,
by a medical literature research expert, by somebody in my office. That's a different story, but that burden is definitely there. And I don't know, you must have come across articles and news reports on these hallucinated citations that attorneys are putting into their briefs,
mhm,
where they are citing cases that don't exist or cases that have nothing to do with the case, the matter that they are using. So, a new use case that a lot of legal tech companies are coming up with is citation verifier,
mhm,
where you upload a brief that you have gotten from the opposing counsel and they will verify if these cases actually exist or not.
mhm,
So maybe it's a good idea for, like somebody to build a citation verifier for any kind of citation, because if somebody has given a citation, it means that they are pointing to a publication, a
mhm,
journal, a volume, a year, a
mhm,
page number. So I think, like, I'm completely with you on that. People need to verify everything that is being filed in court,
mhm.
because you never
Yeah,
know what can be your edge. Yeah.
yeah, something interesting. Yeah, even there's been a bunch of great studies by physicians and researchers looking at if physicians and people that are publishing, if they're even using citations properly, even outside of the legal space.
Yeah.
And there's just this high percentage where people that are publishing in very reputable journals and very, they're an expert in their field and they're inappropriately using citations. They're just dropping some stuff in there, and then when you actually pull the full article and you look
Yeah.
at what it's saying and the data there, it's like, no, this is not supporting what they said it was supporting. So even in well-trained academic experts that have been doing this for a long
Yeah.
time, they're even misusing citations. And I guess maybe they feel like the stakes are low, like, okay, they might get called out on it once in a while or something.
Yeah.
And yeah, when the stakes are high, there's still folks doing it. Yeah.
Hmm.
So,
Yeah. So let's see how AI can have an impact in this direction. What
mhm,
do you think can be, or maybe you're already seeing it, is the impact of AI tools on medical literature research? Like, is it getting easier? Are there any tools that you are aware of that you use? Now, experts cannot use AI or should not use AI to write their
mhm,
reports.
mhm,
But to do research, which you can then verify,
mhm.
do you see AI can have a role where they can help law librarians at least try and find these sources better,
Mhm.
even if they are not really qualified to, like review and understand them?
Yeah.
What's your take on that?
Yeah, I feel like no matter what vocation we have, everybody should be playing around with AI and experimenting with it and seeing how they can use it and being aware of the pitfalls and how it's evolving in their space. In yeah, the legal med mall, we have to be careful because if you just ask chat, hey, give me some articles that support this opinion or that say that XYZ treatment is dangerous or whatever the case may be, it's going to go through, it's not going to do a comprehensive systematic search. It's going to find what is it thinks answers that question. And so it might grab a couple of the more popular articles, and then it's giving you 5 or 10 articles, and you go off and write a report or that informs your opinion. But there's 100 other studies out there, and there's better written ones. It's not good at this point at evaluating the strength of evidence. It might say, well, here's this really bad systematic review from another company or another country where their methods are vague and unclear. And they missed a Cochrane systematic review or a New England Journal of Medicine systematic review where the methods are laid out very clearly. They're just really well done research. And so, yeah, you have to be really careful if you're just getting a tiny sample of what's out there and what's being said. So,
No, that is a big pitfall. And the other problem is that sycophancy is a real issue with all of these chatbots.
mhm,
So if you ask for something, even if the reality is totally different, it
mhm,
will find and it will try to pander to your point of view. And
mhm.
that is a
Oh, yeah.
big, big, big risk, that confirmation bias
Mhm.
that you will get, and then you take it to court, and then the other side just
Mhm.
rips it apart. So, I mean, I completely understand that
Yeah.
could be a big risk. And
Mhm.
that would something that would separate a good attorney from the average
Mhm.
ones when it
Oh,
comes
yeah.
to using AI. What are some other aspects that you think would separate a great plaintiff attorney from the average ones when it comes to using medical literature in their cases?
Yeah. First of all, using medical evidence and literature. And I would say for attorneys and for experts, this advice holds up where kind of using a good balance of medical literature to tell the story of the individual that might would have some sources that might explain the anatomy and physiology. And so that would be a good thing for like a jury and a judge. And so that kind of informs, gives some context to folks that would be making decisions. Then you would maybe have a good mix of literature that might explain this medically complicated procedure to a jury and a judge, and so they can wrap their head around, okay, well, what parts of the body, what systems are at work here, what is this procedure and practice and technology around this? Okay, I understand that. And then I think a really savvy expert or a savvy attorney would have some evidence and outcome data, like what should have happened, what is likely to have happened. Is this is a really maybe a risky procedure, so 10% of the time maybe things don't go well. That would be very important. Or is it 1 out of 10,000 times something doesn't go well? And when that happens, what is often the cause? So I think kind of using a balance of literature to really tell this story of this medical journey that this individual has been on is a good thing for both experts and attorneys to do. And that's going to make it so much more accessible to juries and judges and folks that didn't go to medical school and don't have a heavy science and medical background.
And is there any misconception that you feel that you have seen attorneys have when it comes to medical research and how it kind of applies to their cases?
Mhm. Yeah, I would just say, yeah, back to some of the other things we touched on, that it isn't important. Some attorneys just say, I don't need it. I'm
Mm-hmm.
relying on my experts and appealing to the jury and appealing to
Yeah.
emotionality and other things that they've relied on. So, yeah, I would just caution that a complete lack of evidence is not a good place to be in, and sometimes that's not going to come into play. It's not going to be maybe so much as about the medical evidence, and sometimes it might be all about that. You might have such convincing experts on both sides with identical CVs, and so folks are just going to say, well, I don't know who to
Yeah.
believe. They both were incredibly savvy and communicated well. And the tiebreaker might really come down to, yeah, the medical evidence.
Yeah. So you've created a resource library as well for attorneys, and And you've already said that PubMed is one of the like places where you like to start. Are there any other resources that you think lawyers should bookmark? And we'll add them to the show notes so that anybody listening can go get those links.
Yeah, unfortunately, when it comes to medical and scientific, most of these databases you have to pay for, and
Mhm.
the subscriptions are based on your revenue or maybe FTEs you have. So the larger attorney, the law firms, if you were to go to like Ovid and say, "Hey, I want a subscription to this," they might say, "Okay, well, what's your revenue?" Okay, well, it's X million dollars, and they'd say, "All right,
Mhm.
well, you have to pay us $100,000 a year for access to this database." So unfortunately, so much of the really great tools, they're just not beneficial for an attorney to get and use a handful of times, where, I'm a smaller LLC, I'm more agile, I pay so much less to have access to these tools. But yeah,
Mhm.
PubMed is a big free one. Anybody can access that. And in terms of other free tools, I mean, Google Scholar is great. So Google Scholar, for those who are listening not familiar,
Mhm.
it's different than Google because it's only going to look at like peer-reviewed publications and textbooks and things. But that is an incredibly limited search tool. You're going to miss so much if that's what you're relying on. If you just want to grab a couple articles, that's great. But if you want a really
Mhm.
comprehensive, systematic search, yeah, Google's not the place to go.
Yeah, I think Google's a great place to start,
Mhm.
but that's it. I mean, you really have to dig deeper. I mean, like again, like for example, I just remember this one case where an expert had cited Wikipedia as a source.
Mhm.
And from a research perspective, I mean, you can go to Wikipedia, but then you have to actually, like, they cite everything. They have a
Mhm.
citation to support pretty much everything that they have.
Mhm.
And that is where you then need to look at and then make sure that it's a reliable citation. So, Michael, I also want to talk about the medical case studies that you do on Substack, because I think that's a fabulous service you provide to attorneys and to medical experts both. So why don't you talk to us about that?
Mhm.
What kind of cases you cover? What's your process? And what is the availability? And how can
Mhm.
attorneys and experts benefit from that?
Yeah, thanks for asking. I do a weekly case study on Substack. And so what I'll do is I'll try to find a really interesting, usually med mal case, can be wrongful death. And so I'll dig into all of the legal documents and definitely put a lot of focus on the expert reports. And I'll kind of break those down and I'll try to start off very briefly with like a little bit of the medical context about the individual and kind of tell their story and then what happened. And then I'll look at the opposing experts and I'll put up little screenshots of important parts of their reports, what they said, and kind of break that down and evaluate that. And then I'll point out some odd choices. Maybe there was no literature cited, or yeah, some really strange choices with the research. And I feel like if somebody is new to the med mal space or they're a newer expert, the Substack is pretty valuable because you can look at a ton of other experts' reports and how they choose to approach it and their choices. I feel like it's very beneficial for attorneys that haven't been in the space for decades and experts that maybe they haven't opined a ton. And and then sometimes it's pretty shocking. You will read a story and I'll be immersed in all the research and the documents, and I'll think, well, the jury must have found this way. And it'll be something, a completely different outcome. And I'll even have some experts comment, oh my God, I was so surprised that that's the outcome, the way it
Yeah.
went. And I just love digging into a case a week and seeing how things unfolded and the choices that were made and strategy. And then I learn something every week when I dig into a case also. So it helps
Mhm.
me, yeah, just continuing to learn craft and learn more about this space. So,
Yeah, I think case studies are like, if anybody who's looking to get started as an expert witness, especially
hmm
reading these case studies, seeing how these reports have been written, or even reading deposition transcripts, because a lot of
hmm
experts are worried about being deposed. And it's not just medical experts, all kinds of experts. That
Hmm.
is one reason why a lot of people want to be be consultants behind the scene. They are very happy writing reports, but they don't want to depose, be it arbitration, be it litigation, across fields.
Hmm.
So I think reading deposition transcripts, it kind of allays that fear to a large
Hmm.
extent, that okay, no, it doesn't sound that bad from
Hmm.
the questions and the answers, the back and forth that's happening. And it also helps you understand how to answer difficult questions,
Hmm.
which like somebody may not have that experience. So
Hmm.
that I feel that deposition transcripts as well are a great learning tool, along with the case studies and the expert reports, of
Hmm.
course. So for attorneys looking to work with you, and I don't know any other medical research expert, so I'm going to limit it to you. What questions should they ask to ensure that you are a right fit for the case?
For like a medical librarian and kind of researcher in my role.
Yeah, yeah.
Yeah, I would make sure that they are have kind of a nuanced approach to doing literature searches. That's something that I feel like a lot of folks aren't aware of. There's, I think, 1,600 medical
Yeah.
librarians working in the United States, and I
Very
diff
small number.
a very small number,
Yeah.
and most of them are in academic settings. And I'm on some calls with them, and we use the same systematic search tools, maybe. But where I kind of differ is I don't want to leave anything unfound. So I'll use a lot of other search methods that they might not use just to make sure that something in a database hasn't been tagged incorrectly. Because if a human has not tagged an article correctly, if you do like a mesh term search or a keyword title search and that's all you do, like a lot of medical librarians will do, you're going to miss something. So I think kind of maybe getting into researchers' search strategy and their kind of philosophy is not a bad place to start. Yeah, and obviously making sure it's not just a job and they do a search and they give you the results, but yeah, they have a genuine like curiosity to learn and to grow and to realize that like it doesn't matter if you whatever vocation you're doing, you can spend 50 years in it, but don't ever stop learning and asking questions and being curious. I think getting a feel, that type of feel for somebody is important.
No, this was great. So, Michael, thank you so much for taking out the time to talk to me today and to get into so much details on all these different aspects of how medical research, medical literature research and review can really impact a case, not just medical devices or med-mal, or sorry, like in the MDL cases, but even a regular medical malpractice case. So,
Mhm.
where can our listeners find you, and what is the best way for them to engage your services?
Yeah, so I'm pretty active on LinkedIn. So you can search for Michael Graham, Medical Librarian on LinkedIn, Graham Med Legal Research on LinkedIn, and I post several times a week. And I post a lot on just different aspects of medical literature and searching techniques and different stuff going on in that space. So that's a good place. You can find my website if you just Google Graham Med Legal Research, and you can contact me there. And then also my Substack. Yeah, so I feel like unfortunately Michael Graham's a fairly common name, but so you got to add a little bit of something else, a medical librarian
Yeah.
or Graham Med Legal, and then you'll find me. But yeah.
Only if your name was Ashish Arun, it would have
Yeah,
been easy
yeah.
to
I
find.
wish. Yeah, I wish. Yeah. Hmm.
I really had this thing that maybe I'm the only one, and
Hmm.
then like by this name because they're two first names. Okay, like Arun is also a first name in India. So, and then a few years ago, some kid messaged me on Instagram, and my handle is Ashish Arun everywhere. And he was like, "Hey, can you change your handle? I want this one." I'm like, "Hey, sorry, dude. You were born late, not my fault."
Yeah, that's so funny.
So what we'll do is we'll make sure that we link to your LinkedIn, to your Substack, to your email, and to your website in the show notes. So anybody listening, if you want to get in touch with Michael, learn more about how medical literature research can help you in your case if you're an attorney, or if you're an expert, if you need Michael's help and assistance and guidance in writing your next report or reviewing the opposing expert's report, feel free to get in touch with him. And Michael, thank you so much for your time today. It was lovely talking to you, and I hope to again catch up soon and possibly talk about the new developments in the field, and
Yeah.
hope to talk to you soon.
Yeah, thank you so much for having me. I've really enjoyed our conversation. Thank you.
If you found this podcast useful, remember to subscribe and give us a review on Spotify, Apple Podcast, YouTube, or wherever you listen to podcasts. This will help other users find this podcast and benefit from the insights shared by our guests. If you'd like to be featured as a guest on this show, please write to media@xlightum.com. See you in the next episode.